Hi there. So a lot of you have been asking me about Trudeau's announcement that he intends to resign as Prime Minister and that in the meantime he has prorogued Parliament. So Parliament is on a break. And there are some legal challenges underway right now to the prorogation. These are not our legal challenge. The Canadian Constitution Foundation is not involved, but I'm going to explain what's happening and what I think of these legal challenges and about the decision to prorogue politically and legally. And I'm really curious if you agree or disagree with me about this analysis, because I think I'm pretty confident there's going to be some of you who disagree with me. And you know what? That is okay. Unlike some people, I don't get mad when people disagree with me. I really want to know what you think. And I want to know what you think after you listen to this analysis. Maybe I will change your mind. Maybe I won't change your mind. But let me know. Leave a comment when you're done watching this. So let's get into prorogation, Justin Trudeau, and these legal challenges. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. Okay, so we at the Canadian Constitution Foundation actually have a lot going on right now. We have a Supreme Court and Court of Appeal intervention coming up, the Emergencies Act appeal, the case that we brought, that is being heard the first week of February. We are expecting a result in our legal challenges to British Columbia vaccine passports in the next 2 weeks, finally. And our legal challenge to the Calgary bylaw banning protests near libraries, that is being heard on February 25th. But because of Justin Trudeau, in addition to working on all of those things, now I've had to go and read a bunch of obscure British case law and academic journal articles about prorogation and the Crown prerogative. So I know that most of you who watch this channel you follow the news, but in case you somehow missed this, Justin Trudeau announced that he intends to step down as Prime Minister once a new Liberal leader is picked on March 9th. And while they're picking that leader, Parliament has been prorogued. Prorogation is a Crown prerogative. It's taken on the advice of the Prime Minister, and it terminates a session of Parliament. Parliament can last 4 years, and prorogation is used to divide up that time. It ends one session of Parliament, and generally it kills the bills from that session. And when Parliament is recalled, there is a speech from the throne. We generally start fresh, and when Parliament is prorogued, bills can't pass, but the government can continue to function just without any new funding, because new funding requires parliamentary approval. In order to prorogue Parliament, what happens is the Prime Minister meets with the Governor General and gives the Governor General advice. This is called advice to the Crown, and the advice is to prorogue Parliament, and the Governor General then agrees to do it, usually. This is not new. We are all quite familiar with prorogation. It happens every few years. Justin Trudeau prorogued Parliament in 2020 for about a month after that We Charity scandal had started. Stephen Harper prorogued Parliament in 2010 when there was a bunch of drama around the treatment of Afghan detainees in the Canadian military. And look, prorogation is not always controversial. In fact, it usually isn't controversial. But this time it is controversial, both politically and legally. It's controversial politically because it is really bad timing. Donald Trump has just been inaugurated, and when this prorogation was announced, Trump had just said he is going to impose 25% tariffs on our country, which obviously would be very disruptive and damaging to our economy. So prorogation was announced. We're left with this lame duck prime minister, a new prime minister. We don't even know who it's going to be, and we're not picking him or her. And this new person is going to be negotiating this trade deal with the United States probably right before an election, because I think there's very likely going to be an election. And all of this could obviously have been avoided if Justin Trudeau had seen the writing on the wall that we all saw and resigned 6 months ago. But of course he didn't. Now, the legal controversy is because some people are saying Parliament should not have been prorogued when the House has lost confidence in the government. So in our Westminster system of government, Parliament must have the confidence in the government, and we have confidence votes that show a majority of Parliament continues to support the government. And right now we have a minority government, and that means that some opposition parties need to vote with the government to keep them from falling, to ensure that there's still confidence. And until now, that has been the NDP. Jagmeet Singh's NDP voted with the government on confidence votes as recently as November 28th and December 10th. There was a no confidence motion that was brought by the Conservatives on December 9th, but that failed. But now Jagmeet Singh has said he's done. He will vote to bring down the government at his next opportunity, and he doesn't care who the new Liberal leader is. And some people say that this means that the government no longer has the confidence of Parliament, and so there should be an election. And if the government doesn't have confidence, then there should not have been this prorogation. Now, politically, I think that this is right. There should be an election, and proroguing and running a leadership right now is reckless, irresponsible, selfish. I'm completely disgusted by what Justin Trudeau did here. I think it is bad for our entire country. But legally, I actually do think he had the power to ask for a prorogation, and I don't think there was a legal problem with the Governor General granting it. And I don't like the idea of having the courts review that. Now, let me explain why, because I know some of you are going to disagree with me, which, as I said, of course, is fine, but I want you to understand why I think this. So prorogation is a Crown prerogative. It's a source of executive power, authority, privilege, and immunity that's recognized in common law as belonging to the sovereign, the Crown. The prorogation prerogative is with the Governor General, who, as you know, is an unelected appointed person who is in a largely symbolic role. The Governor General exercises the prerogative power to decide whether or not to accept the advice of the Prime Minister to prorogue Parliament. And I want you to think for a minute about how you want this unelected person to behave. Think about who chooses the Governor General. The Governor General's background, how connected you feel to the Governor General, how much trust you have in them, if you know anything about them at all, or if they would understand your life. Do you want this person to have the power to refuse the advice of the Prime Minister about a political issue like prorogation, a Prime Minister who's elected, who we can unelect if we decide we no longer like him? Now, that's not the law. That's just a few things that I want you to keep in mind while we talk about the law. The legal question that we need to answer is, what discretion does this unelected Governor General have to decline the advice of the Prime Minister? And the answer to that is very unclear. I recently interviewed some experts in this really niche area of law for my television program, Canadian Justice. I interviewed two experts in law and political science, one from Carleton University, one from the University of Ottawa. I'll put a link in the description below to that YouTube channel so you can check out that video. Their names are Paul Daly and Philippe Lagacé, and they said that this is the million-dollar question. Does the Governor General have the authority to decline the advice? And they said if you put 10 scholars in a room to answer that question, you'll get 10 different answers. But their perspective is that if there is discretion to decline the advice of the Prime Minister, if the Governor General has that discretion, it's very narrow discretion, and the situation would need to be quite exceptional for them to decline. Now, others, like Howard Anglin, who writes for The Hub, actually think that the Governor General's decision to prorogue, that was constitutionally questionable, that she did have discretion to decline the advice. But whatever you think of the breadth of that discretion, and I'm inclined to think it's actually pretty narrow discretion that's only for really exceptional circumstances. That's just the could part of the question. Could the Governor General decline the advice? Let's talk about should the Governor General have declined. And remember those points that I made about who the Governor General is: an appointed individual with no accountability in a largely symbolic role. And when we think about if this person should decline the advice, we should consider the last time this actually happened. And it was a really long time ago. The last time it happened was in 1926 during what we call the King Byng crisis. And the circumstances in that case were quite exceptional, and they were very different from what we see today. I'll try to explain the King Byng crisis really pretty quickly. That happened because the Prime Minister in 1926, William Lyon Mackenzie King, he had a minority government, but when he formed that minority government, he and the Governor General had made an agreement that before a new election would be called, the opposition party, the Conservatives, would be given a chance to govern because the Conservatives had a plurality, and Meehan was the leader of the Conservatives. But King broke that agreement. When his government was on the brink of losing a vote in 1926, he asked the Governor General to call an election instead of keeping that promise to let the Conservatives and Meehan try and form a government. And the Governor General, Byng, he declined that advice to the Crown from King, and Byng invited the Conservatives to form the government. King had to resign, and the new Conservative government was formed. Now, the Conservatives quickly lost a confidence vote, and there was an election called, and King ultimately won the election. But the story is important because you're going to hear a lot of people analogizing to this situation, which really at the time, it redefined the role of the Governor General. Because after winning, King, the Prime Minister, sought an imperial conference to redefine the role of the Governor General, and the Governor General would no longer be the representative of the British government, only the monarch. So that was the last time a Governor General declined the advice of a Prime Minister. And I don't really think that the circumstances of Trudeau's request to prorogue are analogous. I don't think that this is at all close to being an extreme example like in the King Byng situation, even though I think that politically prorogation is a really big mistake. In fact, I think that the circumstances around the 2008-2009 prorogation involving Stephen Harper were actually more compelling for a Governor General to exercise that limited discretion and decline the advice. And I still don't think it should have been declined in Harper's situation. So let me tell you about Harper's situation. In late 2008, Harper had been elected with a minority government, and he introduced a fiscal update that made the opposition really angry, as usual. So 6 weeks after that election that Harper had just won, the Liberals and the NDP reached what they said was an agreement to form a minority coalition, with the Bloc Québécois agreeing to provide support on confidence votes. So like a pretty tenuous and theoretical arrangement, but it would have allowed them to function as a working coalition. And Harper, he didn't like this. Obviously, he said that this was an undemocratic backroom deal and an attempt to overturn the election and replace it with a coalition that no one voted for. And there was a sense that this was happening because the opposition didn't like the election result. So facing this theoretical coalition, Harper asked for a prorogation from the Governor General, and he wanted it because prorogation would have helped avoid a defeat for his government by the coalition. It would have avoided a confidence vote. And experts at the time, they debated the different paths that were open to the Governor General when the Governor General was approached with this advice to prorogue Parliament from Harper. And the paths were basically dissolve Parliament and call an election, which had already just happened 6 weeks prior. The other option was to accept the advice and prorogue Parliament. And then the third option, which was perhaps the most controversial, was to dismiss Harper as Prime Minister and invite that theoretical coalition to form government. But what ended up happening was the Governor General just accepted Harper's advice and prorogued Parliament from December 2nd, 2008 until January 26, 2009, with a budget, which would be a confidence vote, happening the next day. And buying this time, Harper was able to kind of come to a new arrangement, and that theoretical coalition never actually formed or really functioned. And I think in that case, if the Governor General has discretion to decline the advice of the Prime Minister, Why should it be exercised in this case with Trudeau, which is a much more typical prorogation than, frankly, than the more controversial scenario in 2008? Now, the second thing I want you to think about when we ask whether we want legal challenges to prorogation is if we want courts and judges to review things like this. The advice to the Crown from the Prime Minister is by its very nature political. Do we want the courts intervening in questions that are so political? In my opinion, no. Now, in this case, we actually don't even have any real evidence that the House, that Parliament, has lost the confidence in the government. In fact, if anything, we have the opposite. There were 2 confidence votes that just passed, November 28th and December 10th, and the Conservatives had a non-confidence vote on December 9th that failed. Now, I know that Jagmeet Singh has said he will vote to bring down the government, but since when do we believe what Jagmeet Singh says? He says a lot of things. Are we just supposed to expect that the Governor General can somehow this time, no, he really means it, read the political tea leaves and say, well, this time Jagmeet's actually going to do it. I believe him this time. That's a terrible idea, especially when there is a real possibility that with a new Liberal leader, Jagmeet cuts some deal and capitulates and decides to support the government. And that's not out of the realm of possibility. That's a very real possibility. And I don't think that I don't think it's at all appropriate to have the courts review this. And that's my opinion. I just don't think this is a question for the courts. And when I first heard that there was a legal challenge to the Prime Minister's advice to prorogue, my gut reaction was, how is this even justiciable? How is this even a question that courts can answer when it's so inherently political in nature? And you might remember at the beginning of this video, I mentioned Howard Anglin, who said that the Governor General could have declined this advice. Well, he thinks that once she's made her decision, that is it. That's what he's written for the hub. The courts then need to butt out. Anglin thinks that there is no role for the courts here because, as I pointed out, these are political decisions. The Prime Minister's advice is political. The Governor General's exercise of discretion is political. The prerogative power is not a legal power. It is not supposed to be reviewed by the courts like this. Now, I mentioned in the beginning also this UK case, this obscure UK case law. Now, there's a case called R. Miller and the Prime Minister. It's a case from 2019. It's sometimes referred to as the Miller 2 decision. So if you hear people talking about Miller 2, this is the case they're talking about. Miller 2 arose because the UK had just voted for Brexit, and the parliament there was supposed to oversee the withdrawal from the European Union. But Parliament and the Prime Minister, Boris Johnson, they couldn't agree about what a negotiated Brexit deal would look like. And they were approaching a statutory deadline that required some fundamental changes to the UK constitution that were going to happen, and they were facing it without a negotiated deal. And this was called hard Brexit without a deal. And it was coming fast. So what Boris Johnson did was he prorogued Parliament. And that prorogation was challenged. And the court in Miller 2 found that the issue was justiciable. Now, the review was of the Prime Minister's advice, not on the Crown's discretion. That was not reviewable. But they said that the court could review the advice of the Prime Minister, Johnson, for whether or not it was lawful advice. And that if the advice would interfere with the functioning of Parliament and the ability to hold government to account, then the government needed to justify the prorogation, which in that case, Boris hadn't done. But in Trudeau's case here, he has given a justification for prorogation. He has said that it needs to happen because Parliament is gridlocked. And there is perhaps some evidence of that, but we also, might not believe Trudeau. I think that he's doing this for other reasons. But the point is he has given a justification, a rationale, and I don't really want the courts then trying to look into that and deciding these highly political questions. And just kind of from the jump, I actually don't know if I even agree with the outcome in the Miller 2 UK case. But even if I did agree with it, the case is basically irrelevant to us here in Canada. It's a foreign jurisdiction, so it just doesn't apply. We have a different constitutional culture, different constitutional convention. interventions. The facts of the UK case were very different, as they will be in every single one of these cases, because it is about politics. And the UK case, in that case, the court said itself in the very opening paragraph that the case arises in circumstances which have never arisen before and are unlikely to ever arise again. It is a one-off. That's their language. So why on earth are we going to give any weight to the one-off decision of a court of a foreign jurisdiction in a highly political context? The reason I think people are giving it weight is because they don't like Trudeau. And look, I don't like Trudeau either. I don't like what he did, but getting the Governor General involved, getting her to exercise this narrow discretion, and then getting the courts to review it, I don't think that's the solution. And I know there are these legal challenges that are proceeding, and I like the people who are involved, the groups that are involved in those challenges. I like a lot of the other work that they do, but I think this case is a loser. I think that bringing it will actually result in a negative precedent that will make prorogation even harder to challenge in the future, if that's what your goal is. I don't know if I agree with that goal either. But really, you just shouldn't bring bad cases, because they actually can do damage to what your larger goals are. So that's what I think, and that's why. But I know a lot of you are excited about this case. I'm not trying to rain on your parade, because I get it. I'm frustrated with what's happening in Canadian politics as well. But let me know if you understand why I think the way that I do. Let me know what you think of my analysis, and let me know if I changed your mind at all. As I said, I don't like what's happening either, but I think the right way to address this current political problem with the Liberal leadership and with Trudeau and with the tariffs and with all of that, I think that the way to address that is with an election that we're going to get either way. If I were going to place a bet, I think that an election gets called at the end of March. So the solution to our problems isn't the courts. It isn't creating a bad precedent. It's just waiting a month and a half. But hey, maybe I'm wrong. Maybe I'll see the decision in this case and I'll change my mind. That could happen. I am open-minded about all of this stuff, and I love learning about this kind of strange area of law. This is just where I have landed so far after reading a bunch of obscure cases, reading a bunch of journal articles, and thinking about it for about a week or so. But, I could change my mind. I want to know what you think, though, so leave a comment below and tell me. Also, if you want to know what's happening in those other cases that I mentioned at the outset, these interventions, the Emergencies Act appeal, the vaccine passport case that's coming out, our challenge to the Calgary protest ban, I'm going to be doing videos updating you about all of that. So subscribe to the channel, because I will have a lot of updates in the coming weeks. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.